despite what happened years ago. And right now we are going live to a press conference at Vera House in Syracuse.
To answer any questions that you might have concerning the Commission's decision regarding former Onondaga County Family Court Judge Brian Hedges. The Commission's case was litigated by Mr. Postel and Mr. Duguay with the assistance of Roberts, and I wanted to recognize the extraordinary work that they did in a relatively short period of time to make this case and this resolution possible. Yesterday, the New York State Commission on Judicial Conduct rendered a decision that Judge Hedges should be removed from office for conduct relating to an event in 1972 in which he engaged in sexual behavior with his then 5-year-old niece. The Commission's determination of removal ensures that Mr. Hedges will never be a judge again, because in New York State, removal from judicial office bars the individual from returning to judicial office. The Commission issued a statement yesterday. Its decision and the related documents are available on its website. My role today here is to answer any questions that you might have, and then I'm told that the victim in this case wishes to make a statement and also to answer questions that you might have. So I'm available to answer whatever inquiries you might have in terms of the Commission and its process and its decision.
Bob, we know we spoke yesterday, and you said you were pretty convinced that this was the right course of action and the right penalty, and as much as you could do as the Commission. I know that a statement has come out from Judge Hedges through his attorney that he said that the allegations, he called them, are untrue. He was disappointed in the Commission. What would your reaction be? Because from what I read, it seemed pretty clear of what his testimony was.
Judge Hedges, as any judge who's disciplined by the Commission, has the right under law to request review by the Court of Appeals, which is New York State's highest court. Both sides will have the opportunity to submit written arguments and then make oral argument to the court. The Commission's decision noted that there were two versions of the event in 1972. There was Ellen Warner's version and there was the judge's version. The referee who presided over the case, William Easton, credited Ms. Warner's version. The Commission noted in its decision that even the judge's version, which admitted that there was sexual contact between him and his niece, was sufficient to support the recommendation of removal because the conduct, in his own words, was so egregious that removal and barring him from returning to judicial office was the appropriate event. We will both make our arguments to the court. He will make whatever argument he believes is appropriate. We will respond to it. Then the court will render its decision.
In his statement, Judge Hedges said that the process is deficient in terms of being a fair fact-finding procedure. Does that hold water?
The process began with formal being served on the judge. He had the opportunity to answer. He had the opportunity and availed himself of a full evidentiary hearing with the rules of evidence applicable before an impartial referee. He had the opportunity after the hearing to submit briefs to the referee. When the referee issued his report crediting Ms. Warner's version of the events, he had and availed himself of the opportunity to submit briefs to the Commission and to appear for oral argument. All of the due process that he received, as any judge who is served with formal disciplinary charges receives, is more than sufficient under law to give him the opportunity to make his case and then to accept or reject whatever judgment the body wishes to impose. In this case, we had a full range of due process opportunities, which he availed himself of, and that's an argument that we would make to the Court of Appeals if he raises it.
In his answer, Mr. Hedges had said that the commission lacked jurisdiction. The event predated his service by about 13 years. What would your response to that be?
We responded to that at the proceedings, both in writing and an oral argument. In summary, the New York State Constitution gives the commission the authority to discipline judges based on their lacking qualifications or fitness to serve as a judge, and for conduct on or off the bench which is prejudicial to the administration of justice. The Court of Appeals, which is New York State's highest court, has said in other cases where the commission removed judges for pre-bench behavior that the commission has the jurisdiction where qualifications and fitness and conduct prejudicial to the administration of justice is called into question to discipline the judge. So the constitutional issue has already been raised in other cases and decided by the Court of Appeals. What is clearly unusual in this case is that the pre-bench behavior was so long ago, which is unusual compared to the other cases that we've had where judges were disciplined for conduct that occurred before they became judges. But what the commission did was it weighed the egregiousness of the behavior against the passage of time and concluded that this conduct was so abhorrent, it was so reprehensible, that removal from office was called for because it challenged or it called into question his fitness to be a judge.
I think you talked a little bit about a message that the ruling sends. I'm sure there are some people who may not understand the law fully will say, geez, the only thing that he's not going to be able to do is be a judge again, keeps his pension, anything like that. So I guess for those who might not know all the ins and outs, what kind of message do you think this does send and should send?
I think there are a number of messages that this decision sends, and they are similar to arguments that I made before the commission before it rendered this decision. First, it's the appropriate punishment, in our view, for the individual who committed this act. Secondly, it's a message to other would-be judges that if they have this sort of behavior in their background, they should not expect to be a judge. They should look for some other career. That this sort of behavior will come out. And if it does, there is a body of New York State government that will appropriately move to remove such an individual from the bench for conduct that is so egregious. Third, I think it sends a message to the public that the integrity of the judiciary will be protected by the commission when it removes unfit individuals from serving. And fourth, and perhaps most significant of all, I think it sends a message to those who are victimized by this sort of behavior that there are mechanisms of government that will respond appropriately when notified and made aware of this sort of behavior. It's my view that it is the responsibility of any responsible entity of government to follow the facts whenever presented with allegations of serious misconduct. And I can think of nothing more serious than an allegation of the sexual misbehavior with a child by an adult. And where appropriate, to render public discipline so that there is, in addition to a message that the judiciary will be protected from unfit incumbents, there is some measure of justice that the victim might derive from this sort of official sanction.
Mr. Tembechian, should there be any concern that at least two members of the commission dissented about what the penalty in this case should be and basically wrote a decision or agreed in that decision that merely having the judge leave the bench and keeping this matter from ever being raised in the public forum handled that way, that was sufficient, that if their side had carried the day, we wouldn't be here and no one would know about this?
I'm not concerned with competing views. Obviously, I disagree with the dissent. More significantly, the majority of the commission disagreed with the dissent. and they concluded that a public resolution was the appropriate result in this case. It's rare to find unanimity in any government entity. There are always competing points of view. I don't, as I indicated, I don't agree with the point of view of the dissent. But in terms of whether we ought to be concerned for the future, I would say here. The originating source of the information, as far as we're concerned, was another government official, the district attorney of Onondaga County, William Fitzpatrick, who also did, in my view, the right thing on concluding that his office did not have jurisdiction to refer this matter to an entity that did. In most significant respects, the process of government worked the way it's supposed to work in this case, starting with the district attorney, going through to the commission, offering the judge the opportunity to defend himself, and then ultimately rendering the right decision.
Normally, commission matters and investigations are confidential right up to the end. Were officials within the Office of Court Administration, the court hierarchy, ever told what was going on so that they did or didn't know what was behind Judge Hedges' sudden departure from the bench in April?
I would have to limit my own comments to what is in the record, which is now public, and there is no information in that public record about when and if and in what manner the commission communicated with the Office of Court Administration. Let me point out that under the law, all commission proceedings are confidential, as you know and you've alluded, unless one of two things happens. The judge waives confidentiality, or the commission renders a public disciplinary decision, which, by force of law, makes the entire proceeding then public. The judge did not waive confidentiality here, so we were not able to make this matter public until after the disciplinary decision was rendered. The commission itself, for 35 years, has advocated with the legislature that its own proceedings should be made public at the point that a judge is formally charged with discipline. In that circumstance, this proceeding would have been made public back in April or May, I should say, early May, when the formal written complaint against the judge was authorized and served. For whatever reason, over the years, various proposals to the legislature to make our proceedings public once the judge is formally charged have not been adopted, and so we operate under the circumstances that we do today. Everything remains confidential until there's a public result.
One of the other extraordinary things about this case is the fact that the victim here, Ellen Cantwell Warner, has become public. What do you say about her decision to actually step out like that?
Well, first of all, I cannot even begin to imagine what it must have been like for her to experience the event and then to carry the knowledge and emotional experience of that event for 4 decades. I think I would obviously defer to her making whatever statements she wishes to make about this. Our responsibility as the Judicial Conduct Commission is to follow the facts and, in my case, to recommend, and in the Commission's case, to impose the appropriate discipline. We did that without necessarily being Ellen's advocate. We were an advocate for the facts. The facts tended to support her, and in that respect, Ellen and my office were going in the same direction. Personally, having met with Ellen Warner, she strikes me as an extraordinary individual, one who has grace and charm and wit, and I'm very happy to have made her acquaintance. Okay, if there are no further questions for me, I'm going to introduce Randy Bregman, who is the Executive Director of Vera House, and my part of today's proceeding is done. Thank you very much.
Thank you to all of you for coming out and helping us to give voice to Ellen today at this long-awaited event. We all wish, those of us I think who've been involved with this case, that District Attorney William Fitzpatrick could be here with us today, but he's out of town and not available. And people are going to coach me to watch my timing for the interpreter. But I did have the chance to talk with the district attorney yesterday again about this decision and his desire that he could be here. And you asked about message and what's the larger message. And one of the things he said to me is, remember to remind Ellen that this day is in fact a triumph of truth over power. And I think that's a very important message. I wish he were here to speak with you directly, because he's been an integral part of our journey to get where we are today. And I think of a triumph of a different kind of power as well, because when he's saying a triumph of truth over power, he's talking about the power that a judge is given by virtue of his role. But I think Ellen is here today with you to talk about a different kind of power, a power that's reclaimed. The power of courage and voice, the power of community and justice, the power of hope and healing. And we wouldn't be here without all of those values today. The community coming together, the courage of many people to give voice, and hope and the opportunity for healing. So I want to add my thank yous to the chain of people that I think led us here today. The first are those courageous survivors who back last fall spoke of being abused at Penn State and Syracuse University. Publicly, Ellen Warner saw those statements and began to think again about the events in her life 40 years ago, and that she had not really had the opportunity for healing. She reached out to her mom, a very courageous woman who, if you follow the documents, was a critically important part of the case. Her mom referred her to counseling. The counselor referred her to a group in Rochester, Advocacy Services for Abused Deaf Victims. Their executive director, Aaron Esposito, is here with us today. Aaron heard who Ellen's alleged perpetrator was and reached out to a sister agency and community to say, how do we work together? And with Ellen's permission, we shared information, and I reached out to Onondaga County District Attorney William Fitzpatrick, knowing we were past the statute of limitations. There was no formal criminal or civil remedy. I honestly had no idea that the commission could have jurisdiction for a long-ago crime. I simply asked the district attorney to join us here in this room a little over 5 months ago to hear Ellen's story and explore what options for justice might exist. He led us to the commission, to the incredible people Bob, Jay, Dave, and Becky have become like family in this community of caring, and to the interpreters, Katie and Chris, and Dave from Rochester is not able to be here today, who all came together to give us the opportunity to hear Ellen's very powerful story. And my biggest thank you is to Ellen Cantwell Warner, who found the courage and strength to tell a story that again belied power and took strength beyond which many of us could ever imagine, and said, I will no longer be silenced. I will give voice, and I will stand before you with my name, and I will tell you my story. And I am now deeply honored and very proud to welcome Ellen to the podium.
My journey started 40 years ago when at the age of 5 I was the victim of sexual abuse at the hands of my uncle. During my life, I suffered the pain of his abuse. Holding it inside, I didn't know how to express it to my parents, my teachers, my close friends. An experience like this is difficult for any child growing up. But it's especially difficult for a deaf child who has limited communication. And he preyed on that deafness. 40 years of trauma has finally come to an end. I'm at peace now. because the truth has set me free. It is as if a butterfly has finally emerged. And now, my mission is to help other abuse victims to find their voice to speak out. They don't need to suffer the emotional trauma alone. Now, speaking directly to the victims of sexual abuse, don't be afraid to tell the authorities to get help or to get counseling. There will be justice for you. People have come in my life for a reason, a season, or a lifetime. And I want to thank some of those special people. To the District Attorney, William Fitzpatrick, who believed in me, believed in my strength. And despite the years that have passed, he found a venue for justice to be served and to help this burden be relieved from my. Thank you to Aaron Esposito and to Sarah Hurd from the Death of Rochester, New York. And they referred me here to Vera House in Syracuse, where I met the most amazing, supportive people named Randy Bregman. Randy has been with me every step of the way, every step of this journey, and she's guided me and helped me to find the strength and the confidence that I myself never know I had. The most important people that I'd like to thank are the staff of the Commission for Judicial Conduct. Bob Tembekian, Jay Postel, David Duguay, and Becky Roberts. They have worked tirelessly on this case, and without them, there would be no justice. And with them, I received the best treatment I've learned from their patients, and I was able to find my voice. I want to thank my mom and my sister very much also, and my 4 beloved children. They have been with me all the way throughout this entire journey. I couldn't have been able to go on without their love and support. They are the everlasting treasures in my life. And I want to thank the 3 most awesome interpreters, Dave, Katie, and Chris. They've been a godsend. I've been blessed for their kindness and their patience. They have shown that through all the ups and downs. And I really appreciate all that they have done for our family. I want to thank you for being a part of my life. And thanks to my husband, Alan, of 23 years, who has been with me to support me throughout. You are my soulmate. Thank you, Alan, and I love you. And I'd like to thank God for never leaving my side. I do thank God. He has never left my side. I'm still on my journey to healing, but now I face this journey being empowered. Thank you.
Ellen, do you have a message?
Just wait one sec.
Ellen,
Go ahead.
do you have a message for Brian Hedges?
I have no comment. You know, he needs to figure this out for himself.
Ellen, how do you feel knowing that the statute of limitations, both civilly and criminally, has run out, and that the only punishment that he is facing is that he can no longer be a judge?
I'm not going to give up. I'm going to continue to work on that bill for the statute of limitations, even though, you know, it wasn't there for me. I think in the future, if it can help other victims, to open opportunities for them. So I think if we can change that law for the 18 and older, I think that's part of my healing, is to help others.
How difficult was it knowing and holding this in for so many years?
It was very, very difficult. You know, when you try to keep a secret inside for yourself, I didn't want to hurt my family members. He's a judge and he had the power, and I didn't know how to get help or how to tell. I had to put my emotions aside. I had to put everything on a shelf and just continue to do what I needed to do. But the trauma still was there for years, affecting me. And that's what I have found when I came here. I found counseling and, you know, to try to find healing and strength. So.
Ellen, take us through the decision in your mind to stand before us today, to have your name, your face, to make this public.
Because I was given the opportunity for other deaf victims out there to see me. I want to give them the opportunity to see me so that they know that they can do it. If I can do this, they can do it. A lot of deaf people hide this information and they don't get the help that they need. So if my name and my picture will help, this is who I am, it will help them.
Ellen, do you plan to do any sort of work in the future to personally reach out to victims, if any were to come forward, in any sort of, just like one-on-one talks or anything?
Yes, I do. Definitely, for sure, yes. Yes, this is a lifetime journey, and yes, I will do that.
Ellen, how much were you, if at all, around Brian Hedges over the past 40 years, whether it was at family functions or something like that? And if so, what was that like?
Well, since my dad and my aunt, you know what's going on, and they knew what was going on, so I felt kind of safer around them. And I didn't obsess on the events because it was a family event, and I didn't want to spoil those weddings and different things that families do. It wasn't easy, but
was there any?
And I didn't want to ruin things for my 4 children. I have 4 children, and I didn't want to ruin their lives growing up. As a mom, my job has always been to protect my children. You know, and if I had said this a long time ago, it might have really caused a lot more turmoil in the family.
Was there a moment where you decided enough is enough and you had to come forward?
It's, you know, I would see the Penn State and the different things from SU on TV, and over the years, I know things have bothered me, but most recently, that just kind of hit me. You know, those victims spoke out, and I thought, gosh, they can do it. Now look at myself, and I'm thinking, you know what, I can do this too. It doesn't matter, you know, if it's a doctor, a baseball player, a coach, anyone can do this, a judge. So I did the best I can to let this out. And it could happen to anyone.
Ellen, what's your reaction to the statement that Brian Hedges put out yesterday, that what he called for allegations are untrue?
I'm not concerned about that because you know what? The evidence is there. It speaks for itself. I'm not going to give up. Okay, is that it? Any more questions, comments, anything? Thank you. Thank you very much.
You were just listening to a press conference live at Vera House in Syracuse where Ellen Cantwell-Warner sharing her very, very emotional story about being abused by her uncle, former Onondaga County Family Court Judge Brian Hedges, years ago, 4 decades ago. But these allegations just came out this year. We're going to have much more on this coming up on the news at noon. Thanks so much for joining us.